I was thinking about starting off with the dismissal of Twitter's challenge yesterday. Should we start from there, or what do you think?
It's up to you. You are the host. So whichever direction you want to go with.
Sure, I think we can start from there. Could you maybe set that up? Like, what was that? Uh, what was the reason for Twitter to file that case in the first place, and what does this dismissal mean? If you could maybe set it up for us and the implications of that, please.
Okay, so Twitter had approached the High Court of Karnataka, and it had been issued orders by the central government under Section 69A of the Information Technology Act. These orders essentially directed Twitter to block access towards certain accounts and URLs which are on Twitter. And Twitter had gone to court and had said that these orders are legally deficient because they are made in secret, they don't contain reasons, the orders are not communicated to the end users, and the orders also are asking for entire accounts to be blocked rather than specific tweets. So there's a legal doctrine called proportionality, and it said that if something is illegal, only to the extent that it is illegal can be prevented from dissemination, not a person's ability to broadcast the other maybe 10,000 tweets that they make, right? So the Karnataka High Court, after months of hearing, gave its decision yesterday, which is on June 30th, 2023, and it dismissed all of Twitter's claims and imposed a cost of about 50 lakhs on it. It agreed with the union government that it had the power to block entire accounts. It also stated that decisions which are not communicated to Twitter in extenso by itself are not required. And it's a 100-page judgment. The Internet Freedom Foundation, where I work, is going to make a explainer blog post around it, and we hope to publish it today. So people who are not lawyers or policy wonks will have a fair background, and they'll at the same point in time get the detail on each of the 8 issues which were demarcated by court. So that's more or less what happened yesterday. Now, in terms of what it means for users, which is the much more meaningful question, right? Decisions are decisions, but outcomes which come towards end users of the internet, like you and me, or the people who are hearing this podcast, is what is much more important. So, the power of blocking specific websites is exercised under a provision which also has certain rules, and these rules state that there are certain steps which need to be followed before a website is ordered to be blocked. Like, the government needs to apply its mind, it needs to see if it's illegal, and it needs to provide an opportunity to the end user for its right to be heard, give a defense, respond to the show cause, and then come to a decision. Now, a lot of these safeguards are actually not enforced at present. The government just does not do it, and the orders are secret by itself. So, what essentially is the outcome of this decision is that government secrecy around website blocking will continue and increase. Secondly, the government may direct the blocking of specific accounts rather than tweets without assigning reasons. And third, because there are also imposition of exemplary costs on Twitter of about 50 lakhs, it may discourage other companies from challenging government practices which infringe upon our freedom of speech and expression. So I hope that that kind of sets out a background of what happened yesterday.
So the first thing that I was wondering about yesterday was why Karnataka High Court? Like, it seems, is there a reason to it?
Yeah. So I don't have insight into Twitter's legal strategy, so I can guess. So I'm hazarding a guess, and all guesses come with certain amount of hazard. I think they chose the Karnataka High Court because, firstly, it does have writ jurisdiction. It can hear these kind of challenges, and they may have selected it because their offices in India may be located within the jurisdiction at Karnataka by itself. Further, they may not, and high courts all over the country have, in fact, in the past, heard challenges around regulations concerning the internet and when they violate freedom of speech and expression. So we've seen activity in the Karnataka High Court, in the Bombay High Court, in the High Court of Judicature at Madras, in Calcutta, in Delhi. So it essentially ends up in terms of a lawyer's choice as to who's the judge there, how fast will we get the decision, what's the likelihood of success. And sometimes that's called forum shopping, but sometimes if jurisdiction is available to a petitioner in 3 or 4 different high courts, then they do and can make a legitimate choice in terms of a place where costs are low, outcomes are expectedly reasonably better. So it's an attempt to improve chances. It's an attempt to improve chances sometimes. So that's what, yeah. But I'm guessing.
Right. On the point where if they had a choice, if they had a choice of high courts in multiple states, and then they chose Karnataka, that seems to have backfired for them, right? I mean,
Yeah,
it's
but
not
like
gone.
it's a hypothetical right now that they had a choice in multiple states, etc. It could be they just had the office there. I do know they had an office in Delhi earlier, which was locked and was raided. So you don't know if they did have offices all over India, because the filing by Twitter by itself was made on the basis of where its India operations are centered, right? So that's the thing. They could have also filed it in possibly in Delhi because the respondents are situated there, or they could have done that because a lot of challenges have been filed in the past in Delhi as well. For instance, Ryan, there is a regulation which was made which would compromise end-to-end encryption. It's a technology which is used to secure private communications on internet messaging services, and a challenge to that regulation, which is there under the IT rules, has in fact been filed at the High Court of Delhi by Facebook and WhatsApp, because the government regulation would end up imposing something called traceability, which would complicate how the technical protection works. So it's not as if it's only Karnataka High Court, there are other high courts as well. And I don't think so I'm qualified enough to say that they made a choice on the basis of them having availability of 4 different courts and it backfired, because I don't have insight into that. And that's not a part of the judgment either.
Right, whatever they made, it didn't really go well for them. I think that is clear. um, I want to come to the judgment. I mean, so there are two aspects to this. One is, um, again, my knowledge in this is very limited, but I'm going to venture into society anyways. So in the sense that I feel like there are two ways, at least the way I'm looking at this. One is that there were certain rules that they were asked to comply, and then they did not comply, but they filed this, they I think they found some issues with the rules that they had to comply with, and then they filed the suit. Again, please correct me in any of the ways I'm going wrong. So that's my assumption. But second of all, so that is one part. But the second part is, when you mentioned about entire accounts being blocked, and where they have the right to block certain accounts, and block certain tweets. um, that seems like even for an average person, that seems like even somebody who's not educated, right, like who has not stepped into any school or college, that seems like a very gross uh, power grab by the government. And it, like, I don't feel like you need to have like a lawyer degree to kind of understand that. But in this case, the judge has not, like, he has not mentioned anything about that, if I'm not wrong. So can you just maybe unpack these two things, whether I'm looking at it correctly, whether I'm making certain assumptions that are probably false? How are you thinking about this?
Okay, so again, I'll say that we are working on such kind of things. Usually, much more clearly communicated in written language, in terms of the specificity or around what was the account blocking, what was the delay in compliance, etc. So I'll just give a flavor of that, and we are working on a public explainer around it because there is a lot of interest around it. So, over, let's say, a timeline of about a year, from 2nd of February 2021 to about 28th of February 2022, which is a year, the government asked Twitter to block about 1,400 accounts, 1,474 accounts, and 175 specific tweets, and it directed that from Twitter. Okay, and Twitter complied with most of them, and only 39 URLs are being challenged by the petitioner in the present petition. Okay, so you have to also see in terms of compliance. And I'm not a spokesperson for Twitter. It's a ad tech company primarily, and its content moderation quite often results in hate speech as well as gender-based violence online. So I'm critical of Twitter, but at the same point in time, one needs to see that the compliance from Twitter is more than 95% easily, right? Because if out of about 1,500 directions, if it's just opposing about 39 URLs, it doesn't mean that it's a persistent violator of the law of the land, which is also something which is in public conversation. So, and with respect to these 39 URLs, we don't know which URLs specifically, because the information is secret. That comes from a rule under Section 69A, in which the URLs which are directed by the union government, as per the understanding of the government itself, need to be secret. So the government does not only prevent the disclosure of the reasons why it is blocking a specific URL, it also does not say what is being blocked. So it's secrecy surrounding this entire process of censorship, which also then leads to Twitter filing this case and submitting these URLs in what is called as a sealed cover, which is why you don't know what are these 39 URLs, what are the reasons, and is it justified? Because our understanding will change very, very drastically if that URL happens to be from an account, and which we know from extremist hate speech, to an account which comes from, let's say, a legitimate media organization, or an activist group the like the Kisan Andolan, or the BBC Punjabi handle, or Caravan India, which have been reportedly blocked under directions of the union government. And that's the first part. And here I think it would be useful for people to just skim through the judgment a bit. Okay, the second part which you're saying is that with respect to even a layperson being able to understand that something seems to be amiss, there's something there's something rotten in the state of Denmark in terms of the accounts itself, rather than a specific URL being blocked. In fact, one should also notice that the case states that the union government tried to block a hashtag by itself, right? So a hashtag being blocked would prevent search and people to organize around it, or even to criticize that hashtag. Just because you're using a hashtag doesn't mean that you are basically joining that movement of people online who are advocating for a specific call to action, right? It's much, much broader. And a little narrower from that is an account. And something which is very specific is an individual tweet, or a Instagram post, or a Reddit post by itself. So here the doctrine of proportionality comes into play. The doctrine of the proportionality which is there is built of our free speech precedent, of constitutional rights, which are contained firstly in the fundamental freedoms in Article 19, where Article 19(1)(a) guarantees us, reaffirms the natural right of freedom of speech and expression. Article 19(2) contains limitations on that right, in which it first opens with the phrase reasonably. And here the phrase reasonably means that anything which is linked to, let's say, a law and order problem or defamation needs to be restricted reasonably. The courts have interpreted it in terms of a very, very vivid metaphor in a case like Rangarajan, is that it should be a spark to a powder keg. It means that the illegality needs to be very, very visible. It needs to be there by itself, and it needs to be proportional. And just because speech which is otherwise legal leads to certain other consequences which may have impacts on law and order, for instance, reporting on a heinous sexual crime in a city may lead to protests, does not make it illegal. So the courts have said that speech by itself needs to be legal, it needs to be limited, and the consequences, which means in terms of the penalties, also need to flow only with respect to that specific article of speech. So this is why, Ryan, it offends the doctrine of proportionality, in which the least invasive, intrusive measures need to be taken to curtail our freedom of speech and expression, because that's the rule and the restriction is the exception.
Um, is this by is it so all this did this start mostly because of the IT rules that were brought in 2019, if I'm 2019 or 21? Is that the are these the result of those laws, or